The Family Medical Leave Act is separate from the ADA, but at times overlaps with it. It is an entitlement granted by Congress, and we will talk about what employers are covered, what employees are covered, what types of leave are available, whether or not it can be paid leave, how much leave is available, other rights you may have under the Family Medical Leave Act, and how you can be required to identify and give notice, and notice required from your employer. So to be eligible as an employee, you must have worked for at least 12 months for that employer, with at least 1,250 hours of work in that 12-month period. So at first hire, you won't be eligible for family medical leave until you've put in a year and put in at least 1,250 hours of work time. Once you've done that, you're eligible, and your continued eligibility is having worked 1,250 hours in the previous or the most recent 12-month period. Your employer can choose to use a calendar year from January to January, or a rolling year based on your start date, or based on your first leave eligibility and request date. An eligible employee, once you're eligible, you are entitled to up to 12 work weeks, 12 weeks of leave during a 12-month period of time. There are a variety of reasons that would support that leave, that would make you eligible for that leave. It could be the birth of a child or the care of a newborn that overlaps with your maternity leave if your company has one. It could be adoption or getting a foster child and needing some leave to get that organized. It could be to care for your spouse, your son, your daughter, a parent who has a serious health condition, and we'll talk in a few minutes about what that is. It could be because of your own serious health condition that makes you unable to perform some aspect of your job. Employers who have 50 or more employees are covered by Family Medical Leave Act. And state and local government employers are covered by the Family Medical Act, regardless of how many employees they are. Congress decided 50 employees, unlike the 15 that are required under the ADA, because family medical leave is an entitlement. It is 3 months of holding a position open for an individual, and it has a fairly significant economic impact, and so they chose 50 as companies that size could afford to cover the entitlement that the Act provides to the individual employees. So if you have a serious health condition, that very much overlaps with the ADA's definition of disability. An injury, an impairment, physical or mental health condition that involves inpatient care or ongoing treatment from a healthcare provider is the phrasing used in the Family Medical Leave Act, rather than a substantial limitation to a major life activity, which is the phrase used in the Americans with Disabilities Act. But they equate to very similar coverage for very similar conditions. The difference is the ADA provides less coverage. It does not require leave for a family member who has a disability, for caring for a family member who has a disability, in the way the Family Medical Leave Act does. Employers may make limited inquiries about your status to make sure you are eligible for FML. There are standardized FML certification forms, and employers can ask for clarity, some additional information on those forms at times. Making those inquiries is not violating the ADA's mandate against asking questions about disability. Clearly, you're already an employee. You initiate the family medical leave process, and so at that point, it's not an inquiry into disability. An employee's own health condition. If you have a serious health condition and are unable to perform, one or more of your essential job functions, you would be eligible for family medical leave. If, on the other hand, you have a serious health condition but can perform all of the functions of your job, all of the essential functions of your job, then you are not eligible for family medical leave, though you may be eligible for an accommodation under the ADA. If, as an employee, there's some aspect of your job, some essential function you cannot perform, but you do not have a serious health condition, you are not entitled to family medical leave. If a family member is unable to care for themselves, if they have a regular set of appointments, if they need some personal care, if they need some assistance with feeding, some intermittent leave or some leave for a period of time while they're in recuperation would be a reasonable leave under the Family Medical Leave Act. That might include someone with a psychological disorder, a mental health condition, someone who gets panic attacks based on a condition and needs some ongoing care or some intermittent care. It would also include the occasional need to substitute because you have an aide that comes in and does care and calls off sick. And that might be a Family Medical Leave Act covered absence to call out the last minute because you got a call in from your aide or attendant saying they couldn't come in to take care of your spouse. So while you're out on leave, your health insurance is maintained. If you have a portion of the insurance that you pay out of wages, you still are obligated to cover your half of the health insurance. But your benefits stay in place while you are covered on family medical leave. If you've been out on continuous leave for 12 weeks and you come back, the employer is obligated to place you in the same or an equivalent job on your return. So if for business necessity they had to fill your slot on the assembly line, couldn't leave it empty for 3 months, would bring things to a halt. When you come back, a job on a similar shift for the same rate of pay, et cetera, would be available to you under the Family Medical Leave Act. It does cover intermittent leave. I've mentioned that a few times in discussing leave. So intermittent leave would be occasional. It would be triggered by some event. It might be that attendant that was late that's taking care of your child with a disability or a spouse with a condition who's in recovery. It might be because I have chemotherapy and I'm on a cycle that most of you will recognize. I'm working, I go in for chemo, I need a week off of continuous leave. I come back from chemo and I need some intermittent leave of only working 5 half days or only working 3 days that first week back because of endurance issues coming back from chemo. Over the course of a few weeks, I progress back up to working full time. And then 2 months down the road, I'm going to need another intermittent leave pattern similar to that because I have another round of chemo. That would be intermittent leave. A flare-up that was unanticipated, a reaction to medication or treatment, those are other things that might require some intermittent leave. When it's foreseeable, it's easier to contend with, and an employer may choose to put you in another position where it's easier to contend with intermittent absences if we know you're going to have 3 to 5 absences over the next any given month, but we don't know exactly when they're going to be. So if you're in a direct customer interaction job, absences may be harder to deal with, and we might move you to a slightly different job as long as it didn't put you in a negative status, as long as it wasn't retaliatory in the sense of you were paid less, were losing opportunities for commission. But if you were on a non-commission sales force and they put you on the phone rather than out front because those absences were harder to cover when you were out in the field doing demos and had to cancel and reschedule, that would be reasonable under the Family Medical Leave Act. FML leave will interact with your earned leave if you have an earned medical leave program at your employer. So if you get 4 weeks of earned medical leave because you've been at work long enough and earned that benefit as an employee, and you take family medical leave for 12 weeks, the first 4 weeks does double duty, unfortunately, or it can do double duty if the employer wants it to do double duty. So you could be paid the first 4 weeks because you have 4 weeks of paid earned leave, and you could drop your balance of paid earned leave down to 0 the first 4 weeks. For the next 8 weeks, because you have another 8 weeks of family medical leave, you are protected out on leave. They have to hold your job for you. They have to keep your benefit package going. But you are not paid. The family medical leave does not require paid leave. And so for the next 8 weeks, it might be unpaid leave. So your employer can set it up to do that double duty if the employer chooses to. And many employees want that because they want the pay the first 4 weeks at work. But that may be a careful decision about what the length of my leave might ultimately look like and whether or not that's to my benefit. But the employer can set it up that way. If you have a choice, your employer can make it a choice. And your employer is obligated to give you some notice about how they're set up, what your eligibility are, when you're running out of leave, etc. To give your employer notice that you are going out on family medical leave, you need to tell them more than I'm sick and I need leave. You need to provide them enough information, and they'll have a form in all likelihood that describes that it's a serious medical condition and that you're under a provider's care. When you call off sick, you might be sick with a cold. You might have overdone it on the weekend and strained your back. It might have nothing to do with your cancer or your disability. In which case, when you call in sick and you have family medical leave eligibility and other kinds of leave you might take, you need to alert your employer that I'm taking family medical leave. You don't necessarily need to tell your immediate supervisor, I'm taking leave for my cancer treatment. I'm taking leave for my depression related to my cancer. You just tell them I'm taking my family medical leave. Many employers, particularly large employers, will separate out the leave forms with all of more personal information on it from your supervisor who is processing your day-to-day, I've called off sick, right? So you can give that information without necessarily revealing all of your condition to your immediate supervisor. Once the 12 weeks are up, if you've used up all your available leave under Family Medical Leave Act, you should get notice that you're about to use up your leave. You can, under the ADA, request an extension of unpaid leave as an accommodation to your disability. When you do that under the ADA, that extension of leave must be bounded. You must be able to, with reasonable reliability, say, here's when I will be back, in a week, in a month, in 3 months, whatever it is, but a reliable return to work date. How much time is going to be an undue burden, how much extension of leave would be problematic for your employer is going to depend on the size of the workforce and the nature of the work. If I have 80 employees who all do similar work and and lots of them like overtime because they would like to earn some extra money. Granting you an extra few weeks of leave is not going to be an undue hardship. But if I have 3 employees and you've already been out for 12 weeks and you're asking for another month of unpaid leave as an accommodation under the ADA, that may be significantly impacting the other 3 employees whom I've told you can't take vacation, you can't schedule appointments during the workday, I need you to pick up a third of this other person's work while they're out on leave. At some point, that may be burdensome on the employer and the other employees, and they would say no under the ADA. But while you're covered by the Family Medical Act, there is no no for any of those kinds of reasons. That's an entitlement. So if you were out on 12 weeks of leave from a sales position, and you did that so that you could receive radiation treatment, and then you request an additional 3 months of leave, if the employer terminated him 8 days later, so that's a hypothetical, that's a set of facts, out on FML, covered and documented, I see the end of my FML and I need another 3 months of leave to be ready to come back to work. I'm a salesperson for this company, and the employer says no. The questions that you might ask if it was a trial, the questions you might ask if it was a complaint with the Equal Employment Opportunity Commission would be, was there a conversation? Was there an interactive, good faith effort to find an accommodation that would meet the needs? If the only thing that would meet your needs were leave, was there additional leave? Was there at least a conversation about could any of this work be done using Skype or FaceTime or the telephone? Were there other accommodations that would allow you to do the critical parts of your job that would not otherwise be getting done? If you can't work, then at some level you're not qualified for work. The question would be, what's the impact of that additional 3 months? And was that a substantial impact on the employer? Was it an undue hardship? Was it truly impacting long-term productivity in business? Or was it simply paying a little extra overtime because other people worked overtime and were happy to do so? So in my previous example, I talked about people who want overtime versus mandating overtime to individuals would be a very different business setup. And if I have to mandate overtime, if I have to say no to vacation requests that people are otherwise entitled for, that additional leave, to make that additional leave for you work, then that might be a reason to say no. So if you cannot return to work, and you cannot identify a reasonable time frame or accommodation that would allow you to work, at the end of that family medical leave process, after you engaged in a reasonable accommodation process, you may be at a point where ending that position, whether you do so voluntarily or whether your employer terminates you, is the only viable option at that stage of the game.